Catholic Social Services in the city of Philadelphia has been providing services and helping with foster care for a long time. I mean, we're going back centuries in Philadelphia. But the city of Philadelphia basically cut them off and will no longer send them children and help them match them up with foster families through Catholic Social Services because of something that was written in an article, in an interview in the Philadelphia Inquirer. Julie Grant has the story that now is in front of the Supreme Court.
Wow, they're all in the forest again.
Sharon Fulton has opened her home to dozens of needy children through Catholic Social Services, a religious agency that provides foster care services for the city of Philadelphia.
What about here? Let me try that. Yeah, I'll do this one.
But Fulton's home is empty, and the agency's ministry is in jeopardy because it refuses to provide services that conflict with its religious beliefs, including working with same-sex couples. That prompted the city to end its contract with Catholic Social Services, igniting a legal battle that's in front of the nation's highest court.
When agencies are getting tax dollars to find families for children in foster care, religious beliefs should not come before the needs of children.
Fulton versus Philadelphia is the latest case to weigh religious expression against the government's interest in protecting LGBTQ rights and enforcing non-discrimination laws. Advocates on both sides of the issue are watching closely for what the case could reveal about the court's newest member, Associate Justice Amy Coney Barrett. Catholic Social Services says it never had to turn away a same-sex couple. But the Philadelphia Archdiocese made its position clear to a reporter in March of 2018, telling the Philadelphia Inquirer that, quote, the Catholic Church does not endorse same-sex unions based upon deeply held religious beliefs and principles. As such, CSS would not be able to consider foster care placement within the context of a same-sex union, end quote. Within days, the city blocked foster care referrals to Catholic Social Services, prompting the agency and foster parents, including Fulton, to sue the city. Attorney Nick Reeves of the Becket Fund for Religious Liberty is part of the team representing the petitioners.
So what the government is arguing in this case is that anytime you partner with the government to provide social services, you basically forfeit your First Amendment rights.
The case pits the petitioners against the city of Philadelphia and two nonprofits who are represented by counsel from the American Civil Liberties Union.
The Supreme Court has long recognized that when governments hire employees or contractors to do the work of the government, they can set religiously neutral conditions for doing that work. Government employees and contractors simply do not have a constitutional right to dictate how government programs operate or to deny services to eligible participants.
A district court ruled in the city's favor, and a federal appeals court upheld the decision. Now the petitioners are appealing.
There are two legal issues in this case. The first is whether, under current precedent, the city of Philadelphia targeted and discriminated against Catholic Social Services because of its religious beliefs. And the second is whether the Supreme Court should reconsider a 30-year-old decision called Employment Division versus Smith. In that case, what the Supreme Court said is, as long as governments treat secular conduct the same as religious conduct, there's no First Amendment violation. And we think that's a problematic decision.
Both sides agree the outcome could have far-reaching implications.
This would apply to religious homeless shelters or religious soup kitchens, prison ministries, anyone else who has to work with the government in some way to serve those in need could be affected by this case.
The ruling that CSS seeks can turn child welfare practice on its head across the country, putting the interests of agencies above the interests of the children they signed up to care for. And it could gut non-discrimination protections in government programs and beyond.
All right, I wanted to fill in a few more of the facts surrounding this controversy. And as you heard in the piece from Julie Grant, Catholic Social Services never had to turn anyone away because no same-sex couple ever came to them. But they also said if the same-sex couple did come to them, there's other agencies that they work with that they could refer them to very easily. They also said they would turn away a couple if they were unmarried, again, based upon their religious beliefs. And Where's this going to go? I don't know. But I do know in the middle of all of this, it's the kids that end up suffering in all of this, right? They're the ones stuck in the middle. It's like a bad divorce. Let's bring back in our think tank, Holly Davis. Speaking of bad divorces, family law attorney. Obviously, in this situation, the Supreme Court handling this, I wish the test was best interest of the child, but I don't think that's going to be the legal test for this one. But what are your thoughts about this? The city jumps in, cancels the contract, despite the fact that no same-sex couple had even been denied anything or turned away. They just decided based on an article in the Philadelphia Inquirer.
Vinny, I think you're giving rise to a good argument that there's really not, the issue's moot right now because there's really not a need because no one's been turned away. But that's not exactly what the Catholic Social Service is requesting. What the lawsuit is saying is that the Catholic Social Services are requesting an exception to a valid and legally enforceable and neutral policy that is created by the city of Philadelphia for religious reasons. And I'm with the lower circuit courts on this. I've got a big problem with the fact that the Catholic Social Services, if I set aside whether or not I think it's right to deny people of same sex, whether or not they could be foster parents or not, which is a different issue altogether, I'd be happy to talk about. But if we set that aside for a minute, we take a look at the actual legal issue. I don't think that the Catholic Social Services is allowed an exception to a valid rule that's applied through for secular groups or religious groups. And Vinny, if you think about it, if we extrapolate as we should this argument out to its logical conclusion, what Catholic Social Services is asking us to do is to allow a firefighter or an EMS worker to refuse to put out a fire at a gay bar for religious reasons. We are opening the doors. If we overturn Employment Division v. Smith through this new Supreme Court case, we've got major problems for the implementation of a lot of these governmental contracts. And it's highly unusual that the lower district court stated, and I agree with, it's highly unusual that a contractor for a government can unilaterally come in and say, I'm not going to follow your discrimination policy, and I demand an exception because of my religion. And if we look at the underlying facts of Employment Division v. Smith 30 years ago that was discussed in the intro, those were two individuals who were in a drug rehabilitation plan who were wanting to smoke peyote as part of what they said was like a religious ceremony, and they didn't want to be discriminated against religiously. And the Supreme Court precedent said that the state could overturn that and say, we don't allow peyote use because we don't allow it for secular groups as well. So if we overturn the Smith decision, we've got some big problems because I think it goes back down to a police officer refusing to provide assistance to someone who's gay, or a firefighter refusing to put out a fire for a gay bar, or in this day and age, a black man, right? We're talking about a major problem with race relations in this country right now, unfortunately. This does seem like my father's country right now, where it stands with race. And so what if we have a religious group who all of a sudden doesn't like black people and doesn't want to administer aid as being part of a governmental contract? We just can't let these things go to these absurd conclusions. So I'm with the lower courts on this.
You know, you mentioned race. Guys, I want you to take a listen to Justice Amy Coney Barrett, who was questioning the attorney for the petitioner today.
Let's take this out of the same-sex marriage context and put it in the interracial marriage context. So Justice Sotomayor was indicating an example like this. What if there was an agency who believed that interracial marriage was an offense against God and therefore objected to certifying interracial couples as foster families? Would they be entitled to an exemption? And if so, how is that distinguishable from, or if not, how is that distinguishable from CSS's refusal to certify children to couples in same-sex marriages?
No, Your Honor. If that case were even to get to strict scrutiny, this court has been clear in Loving and other cases that the government has a compelling interest in eradicating racial discrimination. It's a far cry from here, where Commissioner Ali said that the interest is no stronger or no weaker than enforcing any other policy. It's hard to imagine the city making that kind of concession in a case involving interracial marriage.
All right, guys, we're a little short on time for this segment, but in like 20 seconds, Dave Arenberg, do you think that Catholic Services is going to lose here and they're no longer going to be working with the city of Philadelphia in placing children?
CSS is going to win here at the Supreme Court. This is a different Supreme Court. This is a 6-3 conservative majority, and the new justice has shown her great tolerance for religious arguments. Here's the great irony in this, and then I'll stop, Vinny, is that the Smith decision, which is the one that is going to be overturned, it looks like, by this case, that decision was written and authored by the notorious liberal justice Antonin Scalia, who is Justice Barrett's mentor. That's the irony of all this, that they're going to overturn a decision that he made because it wasn't pro-religion enough.
All right, you're going to break the tie here, Jamie White. What do you think happens?
You know, I agree with Dave. I think it's based on the arguments today that the 6 black coalitions seem to be arguing amongst themselves as to who is going to write the opinion ultimately to overturn Smith. You know, I think that it's going to be really unfortunate. I would just add that, you know, as far as the comment about Loving, it took a long time for the Supreme Court to find a compelling interest to protect African Americans in interracial marriages. For a long time, there was no interest. So I think we need to continue to grow this issue. You know, these families and these people deserve just as much respect as minorities and other protected groups.
All right, we'll see if Justice Holly, when she gets on the court, you know, in a few years, if she's going to overturn the overturned case. All right, when we come back, we're going to go on the docket with a case out of Atlanta. Remember when the Wendy's burned down? Well, there was a case that was a reaction to the shooting death of Rayshard Brooks. We'll break it down next.